Right, good evening, everybody, and welcome to our seminar this evening. As you all know, today is Anti-Slavery Day, and that is that is a day each year that provides an opportunity for organisations like ours to raise awareness of the dangers and consequences of modern slavery, human trafficking, and exploitation. We have chosen a particular theme this year, and that is our focus is on what we have called the unpopular victim, the victim who the state doesn't see as such. So that's why throughout this seminar, we're going to pose the question, what does a victim look like? When you think of a victim of trafficking or modern slavery, what do they look like to you? Is the teenage girl who travels to Syria to join ISIS, is she a victim of trafficking? Is she really a willing and able terrorist who is a threat to national security? And what about her children? What about those who undertake irregular journeys, particularly those who travel through third countries to seek asylum? Have they acted voluntarily? And those irregular migrants who end up working in the most exploitative of circumstances, are they free to leave that work? Have they voluntarily offered themselves to these unscrupulous employers, free to leave should they be harmed? What about exploited children who don't look like children? Are we protecting them or are we punishing them? Should the Palermo Protocol definition apply to all of these so-called unpopular victims too? And we'll also ask, what about the Nationality and Borders Bill? Is it likely to enhance the protection of traffic victims or further erode their rights? These are just some of the questions I hope our speakers will seek to answer. So my name, I should have said, is Maya Sekan, then on my left is Catherine Meredith. And on behalf of the Dowding Street anti-trafficking team, we feel so privileged to be able to share a platform both virtually and physically with the leading thinkers, lawyers, scholars, and practitioners in this field. In a profession so keen on manners, we bring you the opposite. We tonight have an all-women panel, and I'm really proud to be able to say that. So I'm going to stop the gushing and introduce our keynote speaker. We are immensely privileged to have with us this evening Professor Siobhan Mullally. She is a leading academic in human rights law and is currently the director of the Irish Centre for Human Rights at the National University of Ireland, Galway. She previously spent a number of years on the Council of Europe's group of experts on actions against trafficking in human beings. She is currently the UN Special Rapporteur on trafficking in persons, particularly women and girls. She was appointed last year, and she is going to talk to us about ensuring the rights of victims of trafficking without discrimination. So Siobhan, thank you.
Thank you very much, Maya, and thank you very much to Catherine and Maya for the opportunity to join you this evening, and Doughty Street Chambers for hosting this event on European Anti-Trafficking Day, and for choosing this theme also, which is a very challenging one, which challenges us as practitioners, academics, and challenges states to really think about ensuring that the protection of anti-trafficking law applies without discrimination and without exception. So I'm going to talk a little bit about some of the recent work of my mandate as UN Special Rapporteur on Trafficking in Persons, focusing in on this particular theme of non-discrimination, the universality of the promise of universality of anti-trafficking law, and the requirement on states to ensure that the obligations of prevention and protection apply and are given effect without discrimination. Now, in practice, unfortunately, what we see is that the intersections of gender, of race and ethnicity, of migration status, of poverty and disability are very visible in failures by the state to identify victims of trafficking and to ensure effective access to assistance and to protection, including in the implementation of the principle of non-punishment, that victims of trafficking should not be punished for unlawful acts as committed as a direct consequence of being trafficked. And so we see this failure, although the principle of non-discrimination is enshrined in international human rights law, is found in the Palermo Protocol, is found in European human rights law. At the same time, in practice, it's not given effect in anti-trafficking policies and practices. The Office of the High Commissioner for Human Rights has published the recommended principles and guidelines on human rights at international borders, which also highlights the obligation to ensure non-discrimination, to ensure that actions taken to combat human trafficking, either in purpose or effect, are not discriminatory on any of the prohibited grounds. The principle of non-discrimination is again found in the Council of Europe Anti-Trafficking Convention in Article 3. And again, here we see that all of the provisions of the convention, the Anti-Trafficking Convention, shall be secured without discrimination on any ground. So it's a mandatory, absolute obligation, but in practice, unfortunately, we are seeing increasing erosion of these protections. Next slide, please. And this failure to identify victims of trafficking and to ensure effective protection is particularly prevalent where we see the purpose of exploitation being forced criminality or exploitation in criminal activities, including in alleged associations with armed or terrorist groups. And these failings are quite evident, even where there is credible evidence of trafficking that triggers states' positive obligations to take action, to identify victims and to ensure protection. This is something that I've highlighted in my report to the General Assembly, which is looking at the nexus between trafficking and terrorism, the increasing references that we see to trafficking related activities by terrorist groups and armed groups, and at the same time a failure to really bring to the fore the obligations of protection of victims without discrimination. So that's being presented next week to the General Assembly, and it will be interesting to see the response from states in the interactive dialogue. And hopefully there will be good engagement also with civil society around that, because there is a risk that while there is increasing recognition of trafficking activities by armed and terrorist groups, that the human rights obligations are somehow being missed in the responses that are being undertaken. And I should say that the report also highlights concerns around the potential misuse of the label terrorist, of course, and the risks that come with that. We also see in this recognition of trafficking related activities that sometimes women are assumed to be a homogenous group, that we often conflate women and girls as abject victims, and then also reinforce potentially damaging stereotypes of the ideal victim, as Maya said at the beginning, which leads to this failure to meet states' obligations of assistance and protection if a victim does not fit this stereotype. And this perpetuation of gender stereotypes also, of course, hinders timely and correct identification of men and boys as victims of trafficking. And I want to highlight here the work of my colleague, Dr. Noemi Magugliani, who's written extensively on the obstacles to identification and protection faced by adult men as victims of trafficking, and the gendered constructions of vulnerability that we see hindering access to protection. Next slide, please. And I think it's important also in all discussions around anti-trafficking measures that we ensure that there is attention to obligations on states of disability inclusion and effective protection of the rights of persons with disabilities. It's a topic that is often neglected by UN bodies, by civil society, by practitioners, by governments. The CRPD, the UN Committee on the Rights of Persons with Disabilities, has highlighted the impact of harmful stereotypes, discrimination, and lack of procedural and reasonable accommodations on access to justice and to remedies for persons with disabilities. And that is equally applicable in the trafficking context. So victims of trafficking with disabilities often are hindered in terms of access to effective remedies, access to protection, because of the perpetuation of stereotypes and because of failures by states to ensure procedural and reasonable accommodations in all anti-trafficking actions. This is something that we highlighted in the report to the Human Rights Council in June earlier this year, which looked specifically at the implementation of the non-punishment principle, including with regard to victims of trafficking with disabilities. Next slide, please. The European Court of Human Rights, in the now growing body of case law under Article 4 of the European Convention on Human Rights, has repeatedly tried to highlight the obligations, the positive obligations on states to identify and protect victims and to move beyond the prevalent stereotypes of who is a victim. So looking at the Chowdhury and others versus Greece judgment, which was the first judgment on trafficking for the purposes of labor exploitation, there the court highlighted the failings at domestic level, where the adult male victims of trafficking were not identified as such, because there was a perception that they somehow could have left their situation, that their freedom of movement was not compromised. And the court emphasized that restriction on freedom of movement is not a prerequisite as such for a situation to be characterized as human trafficking. And the court also highlighted the situation of vulnerability of the men as migrants without resources in an irregular situation, with a fear of being arrested and deported. And again, highlighted that a situation can change, that prior consent, for example, does not preclude a situation becoming one of exploitation and trafficking. But again, this was something that was missed at domestic level, and it took until the judgment of the European Court of Human Rights to identify the men as victims of trafficking for the purpose of labor exploitation. So it's a very important judgment in terms of breaking down those stereotypes, highlighting the situational vulnerability of migrant workers, in this case, migrant farm workers. Next slide, please. I want to just touch a little bit on the non-punishment principle, because here I think we really see problems in terms of the consequences of failures to identify victims and who doesn't fit the ideal type stereotype. And the punishment of a victim of trafficking marks a rupture or break with what are supposed to be states' commitments to ensure protection of the human rights of victims, to assistance, to protection, and to effective remedies. Next slide, please. And the non-punishment principle was discussed at length by the European Court of Human Rights in the important judgment of AN and VCL versus the UK, where the court said that it was axiomatic that prosecution in this case would be injurious to a victim's physical, psychological, and social recovery, and could potentially leave them vulnerable to being re-trafficked in the future. So they brought the non-punishment principle within the scope of Article 4, the prohibition on slavery, on servitude, forced and compulsory labour, which incorporates the prohibition on trafficking. And importantly, they linked also the non-punishment principle to the right to a fair trial in Article 6, finding breaches of both Articles 4 and 6. And here I think it's important again to recognise the gender dimensions that arose here, where the victims in this case, adolescent boys at the time of coming to the UK, who were trafficked for the purpose of forced criminality, cannabis cultivation, were not initially identified as such. And then even when identified, the prosecution continued with all of the consequences then in terms of gaps, failures of protection and assistance to them. Next slide, please. And importantly, I think, and again, I think this is particularly important in thinking about the Nationality and Borders Bill, the court emphasised that the state could not point to failings by legal representatives, or in particular failures on the part of a defendant, especially a minor defendant, adolescent boys in this case, to tell police or their legal representatives that they were a victim. So again, emphasising that the obligation of identification is on the state. It's not an obligation on victims to self-identify, and particularly, as they said, not for a child victim who's particularly vulnerable. And again, they emphasise that in terms of failures to self-identify, that a victim should not be penalised for such. And this is something that is in fact referenced again in the explanatory notes to the Modern Slavery Act 2015, where there's specific reference to victims sometimes being unwilling to come forward to self-identify, perhaps not seeing themselves as victims, but also to the particular social and cultural barriers that may arise for men in identifying themselves as victims. And that, of course, may also be the case for boys and for women and girls. Next slide. So the principle of non-punishment was something that I looked at as part of my mandate, and building on the work of my predecessor, Maria Grazia Gianmarinaro. And this was part of my report to the Human Rights Council in June. I wanted to look at the wider forms of punishment that we are seeing being applied to victims of trafficking, including arbitrary deprivation of citizenship stripping, forced returns and refoulement, arbitrary arrest and detention, and family separations and refusals of repatriation or provision of consular assistance. And punishment, of course, hinders the possibility of recovery and denies access to justice for victims of trafficking. This is something that's recognized in the Global Compact on Migration, but again, I think is not being given sufficient attention in Objective 10 there of the Global Compact. Next slide, please. So again, just to highlight the range of forms of punishment that we are now seeing being applied to victims of trafficking: exclusion from refugee status, denial of welfare benefits, as well as I said, the refusals to facilitate repatriation or to provide consular assistance. And arbitrary deprivations of citizenship, as we know, have a very troubled and problematic history, rooted in histories of racism and positioned very much at the heart of attempts to limit the universal application of human rights law, or ensure the application of human rights law without discrimination. And deprivation, arbitrary deprivation of nationality, must be understood in itself as a form of punishment, engaging the obligations of non-punishment for victims of trafficking. Next slide, please. The other point that we see discussed, and this is of course particularly relevant to clause 51 of the Nationality and Borders Bill, but the non-punishment principle is often contested by states with regard to its scope and when it should apply. And here I just want to note the work of the Council of Europe, the treaty monitoring body, the group of experts on action against trafficking. Under the Council of Europe Anti-Trafficking Convention, Greta has repeatedly recommended to states that the non-punishment principle should be applied to all offences that victims of trafficking were compelled to commit. That is the language that Greta uses, and has recommended the removal of exceptions, including in its report in the UK, but also in reports to Denmark, to Finland, Germany, Romania, and others. And again, this draws on the work of the OSCE, for example, which has highlighted in its recommendations that the duty of non-punishment should apply to any offence as long as the necessary link with trafficking is established. So without discrimination and without exception, recognising that the victim is a victim of trafficking as such. Next slide, please. And the non-punishment principle, as well as the positive obligations on states under Article 4 of the European Convention on Human Rights, are points that we have highlighted in a submission to the European Court of Human Rights in the ongoing case of HF and MF versus France. The Grand Chamber hearing was just a few weeks ago, and we're now waiting for the judgment. The Special Rapporteur on trafficking in persons, my mandate made a submission in the case, as did the Special Rapporteur on Human Rights and Counterterrorism, and the Council of Europe Commissioner on Human Rights is also an intervening party. So this is a case that raises the question of repatriation to France of 2 women and their children. And in my submission, I raised the positive obligations and the procedural limb of Article 4, the positive obligations on the state to identify, to assist and protect and to facilitate repatriation. Highlighting also the various resolutions of the UN Security Council, which has indicated the obligations on states with regard to victims of trafficking linked with armed groups or terrorist groups. For example, 2427 in 2018, states should recognize that children who are detained for association with armed groups are first and foremost victims of grave abuses of human rights and international humanitarian law and should facilitate their return. Next slide, please. And in this submission, we've referred to a decision of the UN Committee on the Rights of the Child. This is the admissibility decision, but it was very important for the European Court of Human Rights to have this before it. And this is with regard to the obligations of the state party, again, France, and its competence ratione personae with regard to children detained in the camps in northeast Syria, because that was one of the main questions discussed in the Grand Chamber, also the question of jurisdiction. And the Committee on the Rights of the Child has said that the convention is not limited to territorial jurisdiction and applies also with regards to acts that are performed or produce effects outside of its national borders. And it specifically highlighted obligations to provide consular assistance, pointing to a previous decision in a migration context. And here it highlighted that the state had the possibility to take action and could do so, and therefore its obligations were engaged. Next slide, please. And again, this goes back to another Security Council resolution from 2016, which again looks at the obligations on states to identify, assist and protect victims of trafficking, including in conflict settings, and to comprehensively address the rights of victims. The obligation to facilitate repatriation is one of the few mandatory obligations in the Palermo Protocol with regard to assistance. It's found also in the Council of Europe Anti-Trafficking Convention. And again, the obligation of non-discrimination applies. Next slide, please. And then just to conclude, to point to, and I think these will be discussed further, but these points are all relevant to the current bill that is pending, the Nationality and Borders Bill, particularly Part 4. There are other provisions with regard to access to international protection and asylum in particular that are problematic, but I would highlight specifically with regard to Part 4, clauses 46 to 51, all of which raise questions and concerns as to compliance with the Council of Europe Anti-Trafficking Convention, specifically Articles 3, 10, 12, 13, 14, 16 of the Anti-Trafficking Convention, and also with the European Convention on Human Rights, specifically Article 4, but also Articles 13 and 14, the obligation of non-discrimination, the right to effective remedies, as well as obligations under other provisions of international human rights law and the Palermo Protocol itself. So to conclude, I would just emphasize again, the obligations on states to identify, to assist and to protect victims of trafficking apply without discrimination. There is an obligation of non-discrimination in ensuring compliance with international human rights law on the rights of victims of trafficking. Thank you.
Professor Mullally, thank you so much. Just to say to our audience, Professor Mullally will be here and is kindly agreed to stay to take questions later on. So if you do have questions for her, and indeed any of our other speakers, please just put them in the Q&A section, and in due course we'll be able to ask our panelists to answer them. But before I move on to our next speaker, I'm just going to take this quick opportunity for a quick acknowledgement of the fact that both Chowdhury and VCL were cases involving barristers from here, and Catherine on my left was in VCL. So next, our next brilliant speaker.
People.
One of a team, yes, of course. Our next speaker is Dr. Gallagher, who is an international lawyer, a criminal justice practitioner and scholar with over 3 decades of experience working on human rights. She began her international career at the UN, where she served for 12 years, including as a special advisor to Mary Robinson. In her current position as Director General of the Commonwealth Foundation, she is ambassador for the 2.4 billion citizens of the Commonwealth. No small job. Last month, she took over as chair of the board of Girls Not Brides, the global movement that is fighting to end child marriage. And she continues to serve as an academic advisor here at Doughty Street. And we are so pleased to have you here with us. And I know you're going to try and shed some light on the path behind us to provide some context for our discussion on how we got where we are now. And I know you're going to focus on international and regional legal frameworks in order to do that, and also look at where the actual victim fits in to those frameworks. So over to you.
Oh, thanks so much, Maya. And a big thanks to the human trafficking team at Doughty Street for organising such an important event to mark Anti-Slavery Day in Europe. And thank you for inviting me to be part of this panel. I've been working with Catherine, Michelle and Doughty Street colleagues for, I think, well over 5 years now, and it's been an absolute privilege and delight. One of the highlights for me was being able to bring Catherine and Michelle's expertise into the UN's consideration of what we termed, or what member states to the trafficking protocol termed, the problematic aspects of the international legal definition of trafficking. That work, which they were part of, has been really transformational in shedding light on state practice and solidifying our understanding of both rights and obligations. I really encourage anyone who's not yet looked at them to read the UN reports on what abuse of a position of vulnerability actually means, what exploitation means in the context of human trafficking, and how we should understand consent and the idea that it's irrelevant when deciding who is a victim and who is a perpetrator of trafficking. Now, I've decided that I'm comfortable with the idea of being the dinosaur of this excellent panel. And as you said, Maya, my focus and potential contribution really lies in the past. It's the other speakers who have been addressing and will address in a very practical way how we can best use the laws that we have to protect the rights of people who've been exploited. So I will indeed try and shed some light on the path behind us to provide some context for our discussion by looking at how we got here. As you said, my focus is on the international and regional legal frameworks and the guidance that they provide for what we should understand to be an adequate national response to trafficking. Particularly, of course, given our focus today, I want to have a look at the place of victim in these frameworks, specifically what the drafters were thinking of, what they were intending when developing these rules and principles that we're discussing. I think probably the first thing to say is that we shouldn't imagine that there was much of a grand design around pretty much anything. I started working on human trafficking in the late 1990s in the UN when it became clear that political changes in Eastern Europe were opening up new channels of migration that were feeding into sex industries built on deception and coercion. And it was almost coincidentally that stories began bubbling to the surface about the exploitation of young migrant women and girls in the flourishing sex industries of Southeast Asia. I feel like it's really important to understand that at this point, the issue of trafficking as we understand it today, the exploitation of human beings for some kind of gain or profit, was just not on the international agenda, not at all, not in the UN, not in the EU, not anywhere. And the turning point was really the decision by the UN General Assembly to develop a treaty on transnational organized crime, and a subsequent decision to develop a sub-agreement under that to deal specifically with what the UN called back in 1998, the trafficking of migrants. So it didn't take long for member states to realize there were actually two separate issues here. One, the movement of irregular migrants for profit, and two, their long-term exploitation, as well as the exploitation of migrants who might never have been smuggled in the first place. So this is the genesis for the two treaties that the UK and most countries in the world are now party to: the UN Protocol on Migrant Smuggling, and the one we're most concerned with today, the one on trafficking in persons. And it was the trafficking protocol. I've worked on and studied both of these, but it was really the trafficking protocol that turned out to be a game changer. It provided the first ever international legal definition of trafficking, helping to crystallize a phenomenon that for too long had remained undefined and unregulated. And we know when something's not defined carefully, when it's very difficult to attach obligations, it's very difficult to attach rights to, and that's what had happened. But most importantly, perhaps, the protocol ditched the 100-year-old doctrine that trafficking only concerned the cross-border exploitation of women and girls. On a practical level, it confirmed that states, governments, had a legal obligation to identify and protect victims, to prosecute perpetrators, and to prevent future trafficking. It was and continues to be absolutely full of holes, but nevertheless, it represented a huge leap forward, becoming a blueprint for regional laws, including the stronger EU and Council of Europe instruments, and for national laws in most UN member states, including the UK. So what happened during this period has been, I believe, a bit misunderstood. What I mean is that states developing the new legal framework around trafficking really had no idea what they were letting themselves in for, what they were giving away, the world of trouble and scrutiny that they were exposing themselves to. And I'm absolutely convinced that the trafficking protocol would not have been adopted if delegates in Vienna and officials back in capital around the turn of the century realized that this single treaty would unleash something quite revolutionary, that this new legal framework would mean that we could no longer hide or ignore exploitation taking place on their farms and boats, in their brothels and factories, even in private households. Really important point. We're not dealing with new kind of crimes, new forms of exploitation. This has been around forever. The change has been around the legal framework and the exposure. So like the international human rights system itself, I see the legal framework around trafficking as a charmed creature of its time, something that sadly, I believe we could never, ever hope to recreate today. So it's for that reason that we must treasure it. And I'll come back to that in a few minutes. We should, of course, bemoan the many normative weaknesses and implementation gaps, but we would do well to remember that even being able to have a discussion such as we are engaged in this evening is a sign of such progress that it leaves a dinosaur like me a little bit dizzy. So today our focus is on the victim, and once again, the nuanced framing of this discussion that Siobhan has so beautifully captured for us provides a great indicator of just how far we've come. Back in 1999, when I was involved in the drafting of the protocol, and indeed a few years later, when I was reviewing drafts of the Council of Europe Convention, we didn't really discuss victims, except as the object of exploitation and the object of government largesse. We talked about victim-centered approaches, of course, but that didn't mean much beyond trying to get governments to recognise they had an obligation to identify victims correctly, to not lock them up, and to give them at least a few crumbs of support. So maybe we can look at the complicated issues and questions that we face today as a marker of success. It was only by putting the international and regional standards into practice at the national level that it became obvious things were not as simple as the drafters and those helping them, including me, ever imagined. So a good example is actually non-prosecution and non-punishment. When the protocol was being developed, we understood very well that many victims of trafficking coming into contact with national authorities faced almost certain imprisonment or deportation. The efforts of the UN delegation that I led to the negotiating table to get a provision in the protocol about non-prosecution for what we called back then status-related offences failed. I remember some member states saying that it would open the floodgates, giving voice to a generalised fear that was already starting to influence the tone and the direction of the negotiations. Now, a few years later, the Council of Europe Convention took the first modest steps, including in that instrument, a caveat-heavy provision that states parties provide for the possibility of not imposing penalties on victims for their compelled involvement in unlawful activities. And I think it's relevant at this point to note that the definition of trafficking in both the protocol and the convention doesn't refer to involvement in criminal activities as a form of trafficking-related exploitation. And that's because the idea of trafficking for purposes of making money from people through their involvement in criminal activities was not really on our radar. It probably should have been. When we spoke about non-criminalisation or non-prosecution, we and the drafters were thinking about victims being locked up for prostitution or immigration offences. We were also not thinking too hard about the myriad inventive ways in which human beings can exploit each other. I remember being in Australia more than a decade ago and hearing about young Indonesian fishermen who'd been arrested taking boatloads of Middle Eastern migrants to an offshore Australian territory so they could claim asylum. The stories we were hearing made it clear to me that many of these men and boys had been deceived about some aspects of the arrangement. Some of them, in my view, were not migrant smugglers. Rather, they fitted neatly into the international legal definition of trafficking, a conclusion that you probably won't be surprised to hear the Australian government did not support, because that puts them in a different category and it gives them rights. When I was researching the concept of exploitation for the UN, like what it means, how big it is, I came across the early threads of an argument that some people recruited as foreign fighters might also fit the definition of trafficking. Once again, something we never even imagined when these laws were being developed. We never imagined having to think about a person's prior conduct being relevant to whether they deserve to be recognised as a victim of trafficking, another issue that's going to be discussed here this evening. So there's so much more to say, but I'll finish up now with just a couple of observations that might be relevant for what we are looking at tonight. The first of these is that the legal and regulatory framework around trafficking, like that around refugees, is being forced to carry a very heavy load. And sometimes I worry that it's going to break under the strain. Most people, probably everyone in this meeting, is involved in trying to help individuals who are poor, vulnerable, marginalised and abused. There are so many injustices out there, but the tools that we have to deal with them are very blunt and they're very few. The legal and regulatory framework around trafficking has created a small window of opportunity for us to help a tiny proportion of those who need and deserve our help. We should grab hold of that opportunity and run with it, but it's not enough. We should also save at least some of our attention, some of our focus and our energy for exposing the underlying systems that entrench injustice, from gaps in labour laws to procedural unfairness that disproportionately impacts on those who are already on the back foot. And this brings me to my second concluding point. We must take good care of our trafficking laws. They're precious and they're fragile. If they're made to do too much, they will break. The drafters of this legal framework got many things wrong, but I do think they were right in focusing attention and resources on the worst and most egregious forms of human exploitation. We shouldn't have to triage suffering. That's just terrible and wrong. But we need to make careful, strategically wise choices about where we put our attention, our expertise, and our resources. Thank you so much.
Thank you so much, Anne. That was a fantastic look back at where we were, and unfortunately where we're going is the Nationality and Borders Bill, which we will come to in due course. But our next speaker is the immense Maya Foa, my namesake. She's the Joint Executive Director of Reprieve. And I want to say this is the first time I've been on a panel with another Maya. So extra welcome, and thank you so much for joining us from Washington, DC, and for fitting us into your busy schedule. So Maya is the Joint Director of Reprieve. As a number of you will know, that it's an international NGO that fights against the death penalty and state abuses perpetrated in the name of the so-called war on terror, including torture, rendition, extrajudicial execution, and unlawful and arbitrary detention. Maya has many accolades, but she was selected as a World Economic Forum Young Global Leader in 2019. I'm just giving you the highlights. Otherwise, if I told you everything, we'd be here a while. And she's also been awarded a Soros Justice Fellowship. She and Reprieve have been working on the cases of women detained in northeast Syria in the context of the war against ISIS since 2018. And some of you may know that earlier this year, Reprieve published a report which revealed that at least 63% of the women currently detained in northeast Syria are potential victims of trafficking. Maya herself has conducted multiple trips to the region and has interviewed a number of women and is assisting a number of them, including a number of British families, many of whom are victims of trafficking by ISIS. So I'm going to hand over to Maya. She's going to talk a little bit about her work there and I suppose a non-identification of such unpopular victims, as well as the deprivation of British citizenship. So thank you very much, Maya.
Thank you so much also, Maya, and thank you, Catherine, for the invitation. It's a really interesting and important topic, and I'm really delighted to be with you today. So, as you heard in the introduction, we've been working on the cases of women and girls, and indeed a few men and boys who we believe to have been trafficked into Syria and Iraq over the last 5 to 10 years. And in the course of that work, we've done in-depth investigations in the UK, in the cases of British nationals who travelled, but also in Syria and in a few other jurisdictions. And I have, as you heard, conducted lots of interviews with individuals who are currently detained in these camps and detention facilities in Syria. And what's become really clear in doing this work, which didn't start as trafficking work, is the way in which ISIS systematically used trafficking as a strategy as part of its so-called state building project. And what's also emerged in parallel is the reluctance and indeed in many cases refusal by governments to accept or acknowledge that ISIS was a trafficking gang, and trafficking was one of the key strategies used to recruit, transport, and bring people into the so-called caliphate. So I will start, in fact, I'm going to put the timer on. I'll start by just telling you a little bit about some of the cases and clients, obviously anonymized, who I've met with and worked with, and then maybe talk a little bit about some of the government responses to these cases, particularly in the UK. And the UK does stand as an outlier increasingly in its response to the situation in Syria and the individuals detained in the context of the war against ISIS. So starting with some of our cases, you heard about the report. The report shows that at least 63% of and this was on the British women whose cases we analysed, the women who are there would meet the definition of potential victims of trafficking, in that they were trafficked into Syria and Iraq or within that jurisdiction, those jurisdictions. The individuals were recruited or transported through use of force, coercion, very often deceit, to Syria and Iraq for the purposes of, among other things, sexual exploitation, forced labor, domestic servitude. So many of the women that I've met have been British, but I've also met lots of other nationalities as well. And as I say, what's so striking to me is the similarity in many of their stories and the ways in which they were tricked, deceived, coerced, or forced to go to that territory. I'll talk about one woman here from a European country who described for me the way in which she ended up. She's actually out of the camp now, but she was in the camp when I met her. She described to me what had happened to her. And she said she had been she was a teenager when she got married. She got married to a man who was pretty controlling and abusive, but she came from quite a conservative family, didn't want to divorce him, didn't want to bring shame on the family. She ended up pregnant, still a teenager, and he left. And she didn't know where he was. She was pretty distraught, even though he had continued to abuse her through her pregnancy. And then she heard from him that he had gone to Syria. She didn't want to go, but she did want her child to know her husband was in a pretty desperate state. He persuaded her to travel and meet in Turkey so that they could talk it all through. And her conviction at this point was that she would be able to persuade him to come back and be a father to her child. She gets to Turkey, and she's in a country, doesn't speak the language, and is met by not her husband, but a friend of her husband. And this friend says, no, I'm going to take you to your husband. He's just down here. We just need to take a short drive. She gets into this car with this man. She doesn't know what else she's to do. And she goes to the next spot. And there, she's not greeted by her husband. She is met by another man in another car and told that her husband's over here. Anyway, she gets bundled from car to car, ends up, at a certain point, absolutely terrified, and is told that she's in Syria. And thereafter, her story is like many, many others. And I'll go into a little bit of what happens to these women and girls when they arrive in Syria in a moment. But in her instance, in her case, that was one of those examples where I think she really had no idea what was going to happen to her. And perhaps one of the cases where people are more willing to think of her as a traditional victim. Having said that, she was not treated like a victim once she arrived in the camps by her government. Other women have had some similar elements of their stories, but were aware of where they were going, but not what they were heading into. So many of the cases that we've investigated and women that I've met were groomed online. A lot of them were approached by would-be suitors on dating sites. Recruiters used Muslim faith dating sites to identify targets who they would then marry or try to convince or coerce into traveling with them to Syria and Iraq. That happened in a number of cases, and I've got a few dating apps in a bunch of different countries where there were repeated recruitment. There was repeated recruitment through these particular sites of women with particular vulnerabilities. Some of the women were taken by older relatives or their husbands. These were women and girls, I should say. Many were pregnant or had very young children and didn't want their children to grow up without a father figure. I think the way children were used as leverage for some of these by ISIS, both in terms of the recruitment, transportation, and then once the women were within ISIS territory is quite significant and something that has been underexplored to date. And then some of the teenagers and younger women, as you will have heard about, were targeted through social media apps, including Twitter. And I talked to quite a few of these girls about what they were told at the time, and they described how their recruiters would tell them, would just describe this paradise that they were going to go to, and tell them about what life was going to be like, and they would be welcomed and they would be free and they would have all of these different things and they'd be able to live among like-minded people. And of course, the disconnect between the lies that they were sold and the reality was unthinkable. From the moment the women and girls arrived, and this is typical in all of the interviews that I did, they were immediately detained by people carrying weapons and subjected to various forms of violence. Unmarried women and girls were held in detention. A lot of people call these modafas, guest houses, but they are, to me, that's not right. This was house arrest and prisons. They were hundreds of people in these houses, really overcrowded, awful conditions, and they were forced to work. They were not allowed to leave. The modafas were guarded, and the only way you could leave would be to enter into a forced marriage. Girls as young as 9 were forced into marriages. One woman who was in her early 20s when she was in the modafa described she had a 6-year-old daughter who she said was, unfortunately, she said, very pretty, and she was in tears as she told me how the men would size up her daughter for marriage, even though she was just 6 years old. And she and a few others described how, you know, people were desperate to leave the modafa, this forced servitude and imprisonment, and sometimes they left just to get out, so they married people to get out of that. And other times to protect younger family members, including in this case, the 6-year-old daughter. Once married, or if they entered when they were married, women were there to bear children, many forced into domestic servitude. They report being watched at all times, unable to move about freely. Some of the women I met described their husbands starving, beating them, raping them. Many were subjected to exploitation, violence, sexual exploitation and abuse. And if they tried to leave or escape, and this is important, which they were not allowed to do, they would be imprisoned, beaten, and critically separated from their children. Children were, as I say, used as leverage in quite a sophisticated way, and women would be threatened. One woman described how she was allowed to leave, but her husband was very abusive. She wanted to leave, and he took her to, you know, the authority in the territory to get the divorce that she wanted. And he went in, she was left being looked after by another man, and he came out smiling. And this man was really vicious. And she said to me, the woman describing this, she said, I couldn't understand why he was smiling. I was really worried, what's going to happen now? And then he came back into the car and he said, you can go. And she was, you know, overjoyed and shocked. And then he said, but I'm keeping X, who was her daughter. And of course she didn't leave because she couldn't leave her child with this man. The reason I focus on that in part is that the way the government and the media has described the people who are in the camps now is as the holdouts, you know, the people who only gave themselves away after the fall of Baghouz. And that is just so wrong, I think deliberately misleading, because most of the people who are there now are actually the people who were unable to escape, many of them the most vulnerable and the most abused. And once they managed to get out, you know, they finally sort of fled into Kurdish territory in order to escape ISIS. So as I say, trafficking by ISIS through these interviews and through what we've discovered was absolutely systematic. It was strategic, and women were trafficked into the territory, within the territory with their children, and they are at very real live risk of re-trafficking now. And I won't go into detail on boys and men. One, in respect of the men, we haven't been allowed to meet with any, but I absolutely am persuaded from what we know of their cases and the operation of ISIS, as well as what we know from the boys who we have been able to meet, who are in detention centres, some of them, is that there will be victims of trafficking among that group too, of course, and that is a phenomenon that we want to look at more as well as we move forward. So just briefly now, because you've heard a little bit about it and I have some time, I'll talk about what the government has done in response to hearing about some of our cases. We have over many years now been communicating, less so recently, but communicating with the government, first in really good faith. When we discovered that there were these groups of British families who were detained in northeast Syria, many of whom it was quite clear from the outset might be victims of trafficking, we spoke with the Foreign and Commonwealth Office, or Foreign Commonwealth and Development Office. They asked us to submit briefings on these individuals. We did a lot of work on their cases, looked at their situation, how they got there, their lives prior to travel, managed at the time to have some conversations with them, with family members. And in our briefings, where we didn't say too much, but we did say that a number of them were potential victims of trafficking. In response to these briefings, the British government wrote back and said, in all the cases, it was Christmas 2019, and I'll come back to that, they said, we are not going to repatriate, which was our request, these individuals. There were stock letters, all the same, and I received all of them between, I think, the 18th and 22nd of December that year. We're not going to repatriate on the basis that they are a threat to national security and they have been stripped of their citizenship. This was the first they had learned of this. Additionally, we would consider separating their children and bringing their children back without them if they consent to this to another party, i.e. us. This was absolutely shocking at the time. And now, sadly, I'm much less shocked by it. It was blanket. It was in all cases. It was the same letter. It paid no regard to the fact that we had flagged that some of these people might have been victims of trafficking. And then obviously, since then, we have gone back with many of the cases trying to seek, trying to get them to change their position on these cases. They haven't yet. And they have now communicated with us in various other ways their position. So they've refused to identify any of the individuals as victims of human trafficking. What they say in response to a letter that we sent saying that they ought to, in one case, which we had developed a little further, subsequent to the 2019 briefings, they said, no domestic law or policy requires the UK government to make determinations of whether persons presently situated outside of the United Kingdom are victims of human trafficking, or to arrange for persons outside of the United Kingdom who claim to be victims of trafficking to be brought to this country so a determination can be made of whether they are victims of trafficking. So they're seeking to say that they don't have any legal obligation to assess or consider people if they're outside of the jurisdiction. But in other cases, they have sought to blame the women directly for their own exploitation and abuse and said that they travelled of their own volition, having done no investigations, and alongside that have peddled these very harmful stereotypes, which the language in and of itself is prosecutorial and doesn't allow for the potential that they might be victims. So calling them ISIS brides, saying that they co-located with ISIS and that is the reason that they are being stripped of their citizenship. And as Professor Mullally has said, this citizenship stripping is another form, it's both a form of punishment and it's a violation of the non-punishment principle. What we've seen here is the UK turning citizenship stripping from a power that was invoked extremely rarely into what appears to us now to be a standard operating procedure to collectively punish all women who they say co-located with ISIS of their own volition. Again, we would contest all of that without doing any investigation into whether they were trafficked. And in so doing, they are leaving many of their nationals stateless effectively and practically. Some of the SIAC cases have resulted in the rulings, the deprivation orders being overturned. But what that just shows you is that you can leave people for years that they cynically deprive, knowing that these individuals may not have a right to a secondary citizenship. And they spend years in these camps where they are at risk of all sorts of abuses, at risk of being transferred to Iraq to face torture and the death penalty, at risk of being of the camps being opened up and them ending up in Syria, where again they'd face torture and death, and at risk of re-trafficking, as I've said. And finally, of course, the refusal to repatriate and the suggestion of family separation is another way in which the British government has sought to really just target and punish these individuals with the most extreme acts that they have, the most extreme measures they have in their armory. And what we think, looking at this in terms of your, the topic under discussion, this is of course a set of measures that are part of a wider policy that is intended to exclude unpopular victims from protection. We know that the British government is very alive to the idea of these women, the presentation of the women in the media and the public perception of these women. Not only are they alive to it, they are actually stoking, I think using racist dog whistles to try and win votes, actually, and they are stoking this very hostile media representation of the people who are currently out there. One of the things that we've looked at, and this is, I'll end shortly, one of the points that we've looked at is the way the British government has sought in the last couple of years to define trafficking, to exclude victims of trafficking by terrorist organizations from the definition of trafficking. And you'll know, many of you, and I'm sure some of the people on this call may have worked on it, that in a case last year, it was revealed that a boy who had been trafficked by the Taliban in Afghanistan, the Home Office had been applying an unpublished policy saying they do not consider, I'm quoting, that terrorism or potential acts of terrorism fall under the definition of modern slavery. The case, of course, was settled, and the Home Office was forced to concede that this was a misunderstanding of the law, that victims of trafficking by terrorist groups can meet the definition of trafficking under the Modern Slavery Act. But I mention it because the unpublished policy was in operation at the same time that the UK government sent out those letters I mentioned in December 2019 to at least 5 British women who were detained in northeast Syria, communicating their decisions to strip them of their citizenship and refuse to repatriate them. The government was aware of the suggestion that these women might be potential victims of trafficking, or were potential victims of trafficking, from the evidence that Reprieve had put forward, and nevertheless determined that they were, hostile, that they were a threat to national security, and that they couldn't be repatriated. So having been forced through the litigation to concede their policy represented a misunderstanding of the law, though not having taken any different action on our cases, the government is now seeking to put this unlawful policy into statute through clause 51 of the awful the Nationality and Borders Bill, which I think we're going to hear more about, so I won't go into detail there. But the top line is it purports to allow the government to disqualify potential victims of trafficking from protection if they can claim that these people are associated with terrorism, which of course they will be able to do in all cases of individuals, including children who are detained in the camps in northeast Syria. And the consequence of this in terms of the law is, of course, it'll make the detection and prosecution of terrorist networks much, much harder. And it'll also send a really worrying message to groups like ISIS that they can use trafficking with impunity because victims of trafficking by terrorist groups won't be recognized. And I think I'll just end by coming back to this point that we are dealing with a really complex phenomenon. It's clear from the numbers, and I think it is higher than 63% outside of Britain, but that's the analysis that we've done, that trafficking was a key tactic of ISIS, and it will be used again, and it will be being used in terms of re-trafficking. And whilst it's complex, I think that's the reason the government doesn't want to deal with it, the reason they want to create this carve-out. But if we don't deal with it now, we are only going to make things worse for the victims right now, but also future victims. So I'm really glad that we're having this conversation and looking forward to continuing it in the Q&A. Thank you.
Maya, thank you so much for that profoundly depressing and distressing insight into the stark realities of being a so-called ISIS bride, and in fact for providing a counter-narrative to the current hostile media reporting. It's amazing for us to hear from somebody who's actually been there and been on the ground. So continuing with this theme, we have our next amazing woman is Michelle Noor, who is a barrister here at Doughty Street. She specialises in public law, human rights and asylum. And since around 2015, Michelle has been heavily involved in representing unaccompanied child asylum seekers in Europe to open up legal routes for reunion with family members in the UK. And a significant number of those children were trafficked during their migration journey or at risk of trafficking when forced to use irregular routes. She's also been involved in test litigation challenging the UK's new asylum claim inadmissibility policy as it applies to potential VOTs. She's going to speak about those unpopular victims who are punished rather than protected by both the immigration and criminal justice systems. So she's going to look a bit at those who undertake irregular journeys, particularly those who travel through third countries, and also those who end up committing offences directly connected to their trafficking status. Thank you very much, Michelle.
Thank you so much, Maya. Yes, so I'm going to focus on two categories of unpopular trafficking victim who are targeted by the UK's domestic policies in ways that I consider clearly violate the UK's obligations to protect victims of trafficking that we have been hearing about in the discussion so far today. So first, I'm going to look at asylum seekers who undertake irregular migration journeys and who are also victims of trafficking. And second, I'll look at the victims of trafficking who are convicted of criminal offences. If you could go to the next slide, please. So there is a lack of safe and legal routes to seek asylum, and this creates a high risk of trafficking amongst refugees. For example, there is a very high risk for refugees who travel through Libya and are seeking to cross the Mediterranean in order to reach Europe. The recent report that's dated 1st of October by the UN Human Rights Council independent fact-finding mission on Libya considers the practice of interception of migrants who were seeking to cross from Libya to Europe by the Libyan coast guards. Now, those migrants who are intercepted by the Libyan coast guards are often then trafficked and exploited in Libyan government detention centres or through being sold to people traffickers. And I wanted to draw out the quite shocking conclusion of this independent fact-finding mission report as it concerns those migrants. It is, as set out on the slide, that there are reasonable grounds to believe that acts of murder, enslavement, torture, imprisonment, rape, persecution, and other inhumane acts committed against migrants form part of a systemic and widespread attack directed at this population in furtherance of a state policy. As such, these acts may amount to crimes against humanity. Now, the conclusion also recognises that finding is made notwithstanding the responsibility that may be borne by third states, and notes that further investigations are required. Now, that can only be a reference to the fact that the Libyan Coast Guard and those migrant detention centres are funded through the EU and the UK, whose focus is to stop migrants reaching Europe, and thus they are likely complicit in those crimes that have been identified. Now, obviously, it's not only migrants who travel through Libya. Trafficking is prevalent on other migration routes, with refugees and migrants facing exploitation in order to pay for expensive, irregular journeys facilitated by traffickers or smugglers. Next slide, please. So we've seen that migration policy drives refugees into the hands of traffickers. At the same time, there is an ever-increasing appetite to punish those who take those journeys, particularly those who travel through third countries where it's considered that they should have claimed asylum rather than continuing on to the UK. And we can see that appetite for punishment in the Nationality and Borders Bill, which I know Zoe is going to cover in some more detail and which has already been mentioned by other speakers. We also see this in the deliberate failure during 2020 to ask those who were arriving in the UK on small boats asylum screening questions that were designed to identify victims of trafficking. And this can only, we can only assume that this was part of a cynical plan to remove those who may have been victims of trafficking while ignoring their entitlements to identification and support as victims of trafficking. The denial of protection for victims of trafficking who have travelled through irregular routes and are seeking asylum is also apparent in the UK's new inadmissibility policy, which defines whether or not an asylum claim will be considered in the UK or whether it will be declared inadmissible and therefore the person will be returned to another country for that claim to be processed. Now, this new policy was reformulated on the 31st of December 2020 after completion of withdrawal from the EU and also withdrawal, therefore, from the Dublin arrangements that previously allowed the UK to return many asylum seekers who had passed through EU member states. Now, under the new policy, an asylum claim may be declared inadmissible where the applicant has travelled through a safe third country, but it's necessary in order to complete that inadmissibility decision for a third country, and I note that could be any third country, to accept the transfer of the person back. Now, that poses some difficulty at the moment because there are no bilateral agreements, there's no new agreement with the EU, and obviously the most common countries for people to have just travelled through on the way to the UK that could be considered safe for asylum purposes are EU member states. So there is a practical barrier to actually making inadmissibility decisions at the moment. Now, generally, there is a 6-month long stop time frame to secure any one of these return agreements. And the policy provides that if there is no reasonable prospect of return within the 6 months of the asylum claim being lodged, then it should be admitted for substantive consideration in the UK. So for all asylum seekers, there should be this 6-month window, which presently, due to not having return agreements, it's very unlikely that any return will be agreed within a 6-month period. Now, victims of trafficking are, however, singled out under this policy and treated less favourably than other asylum seekers. For potential victims of trafficking, that 6-month period is paused under the policy from the point of referral into the NRM until exit from the NRM obviously being the body that is identifying them as a victim of trafficking. And that means that potential victims of trafficking have their asylum claims on pause for potentially years while they are being identified, because we know that there are really serious delays, particularly where someone has had a positive reasonable grounds decision. So there is a reasonable suspicion that they are a victim of trafficking, but has not yet been identified conclusively as a victim of trafficking. Now, that means that those victim of trafficking asylum seekers are left in limbo in an insecure position and their recovery is undermined, whereas otherwise, had they not migrated through a third country, they could have had a swift decision on their asylum claim. And that's particularly the case for those victims of trafficking who are from countries such as Eritrea or from South Sudan. Those will often be the people who are trafficked, for example, through Libya, and who are very clearly refugees and therefore would likely get a positive, swift asylum grant and not necessarily have their asylum decision in any event awaited the conclusive grounds decision. So this policy is targeted at victims of trafficking and is highly disadvantageous to them. It's also, I'd consider, clearly inconsistent with the principle enshrined in Article 40 of the Convention on Action Against Trafficking in Human Beings, that the right to seek asylum should not be prejudiced on account of being a victim of trafficking. It's also likely to be contrary to Article 4 of the European Convention on Human Rights and the obligation to protect victims of trafficking, and it is also discriminatory. It's also probably inconsistent with the immigration rules themselves, which provide that a claim should be admitted if removal to a safe third country within a reasonable period is unlikely. So this policy of pausing is actually within a policy that sits behind the immigration rules, and it's arguably inconsistent with the rules themselves. Now, I have been working on a challenge to this policy with Ashling at Wilson Solicitors. We did get permission to challenge it, and then, of course, post permission, the Secretary of State decided not to apply the policy to our clients any longer. So we have had to settle that claim, but it is something that, in my view, clearly should be challenged. The next slide, please. So now, turning to victims of trafficking who are convicted of offences in the UK, and we've already heard of the sort of offences that someone who was trafficked might well end up committing and therefore being convicted of, offences such as cannabis cultivation or acting as a drug mule. There may be other offences that are not necessarily the exploitation in criminal activities, which is part of their trafficking experience, but offences such as the use of false documents or fraud offences that are committed at the direction of traffickers and have a nexus to their trafficking. Now, the victims are frequently prosecuted for these offences, even where they are compelled to commit them in the course of being trafficked. And we have heard from Siobhan about the really serious impact that those prosecutions have on victims of trafficking. And we've also heard that they should be protected against those prosecutions by the non-punishment provisions in the Article 26 of the Convention on Action Against Trafficking in Human Beings, and also Article 8 of the EU directives. Now, we've also already touched on the case of VCL and AN in UK, which is a really phenomenal judgment that confirms, importantly, that Article 4 of the European Convention on Human Rights encompasses the non-punishment principle and finds that a failure to protect a victim of trafficking against prosecution may violate the operational obligation under Article 4 ECHR to protect. It also, as we've heard, recognises the importance of identification of victims of trafficking and at an early stage, and provides that, that those who are prosecuting potential trafficking victims should accept the assessment on whether someone is trafficked conducted by the competent authorities, unless there are clear reasons for not accepting that assessment. And it's important that point that you must accept that assessment absent clear reasons for not doing so, that those reasons must be connected to the definition of trafficking contained in the convention. And so in VCL, for example, the police did have, and prosecutors did have reasons for not following the competent authority decision, but they were things such as that the victim of trafficking had a mobile phone, and nothing about that was actually inconsistent with them being a victim of trafficking as defined in the convention. So those type of reasons were rejected. Now, this case is really, really important from a domestic perspective in interpreting the scope of the positive obligation under Article 4, and it really gives teeth to the non-punishment provision in the convention. It's not, however, a panacea. There is scope for departing from the competent authority assessment, though as above, that is limited, and limited in very important ways. We also know that on many cases, there has been no competent authority assessment and no identification of victims. And we still, in many cases, are dependent on police and prosecutors identifying victims at a very early stage in order to prevent violation of the rights of victims of trafficking. Now, VCL is very helpful for that because it places the obligation squarely on prosecutors, does not shift it to victims, as has been the case in the past. But there is still real risks that victims will not be identified and will be prosecuted as they have been. There are also complexities concerning the nexus of the offence and trafficking and whether there was compulsion to commit the offence. Now, in some circumstances, compulsion is really obvious where there are direct threats to the victim, but in all too many cases, the compulsion is really connected with abuse of a position of vulnerability. This is a much more subtle and nuanced, and I'd suggest following Anne's advice and reading the documents that have been put out by the UN on the meaning of these terms, because that can really help in trying to assist in defining cases and holding the authorities to account in ensuring that victims who are compelled to commit offences are recognised as having been so compelled. Now, finally, if we can turn to the fourth slide, I just want to mention automatic deportation, because we have provisions for automatic deportation that apply to any convicted person who receives a sentence of 12 months or more. There are, however, exceptions to automatic deportation, where deportation would breach Article 4 of the ECHR, or where they would breach the provisions of the Convention Against Trafficking in Human Beings. Home Office guidance recognises that it would breach that convention to deport a potential victim of trafficking within the recovery and reflection period. So once they have a positive reasonable grounds decision, but before the conclusive grounds decision. The guidance also explains that once there is a negative conclusive grounds decision, there's no longer a barrier to automatic deportation. But there is no guidance whatsoever on what to do if someone receives a positive conclusive grounds decision and they are in fact a victim of trafficking. Now, that is a really significant lacuna in the guidance and fails to recognise that it's very likely to be contrary to Article 4 and the non-punishment principle in the Convention to deport a victim of trafficking where there is a sufficient nexus between the offence and trafficking. And that's the case even where the conviction stands. So again, this is something that I've been involved in trying to challenge, and I know others have, but none of the cases have ever ended up in court and deciding whether this guidance is defective for various reasons. But another thing to watch out for and to push on if you have a case that raises this sort of issue. So to wrap up, while the law on protection of victims of trafficking is strengthening and is impressive, UK policy continues to undermine those protections and to punish these categories of unpopular victims. Thanks.
Thank you so much, Michelle. That was a brilliant whistle-stop tour through, the criminal and immigration regimes. Of course, whenever our government puts international regional instruments on the statute book, that is when we start worrying, as we have seen Article 26 and Article 26 of ECAT and Article 8 of the EU directive have been put onto the statute book, or ostensibly so, in the form of Section 45 of the Modern Slavery Act. And we've now had to live with the ramifications of having a statutory defence as opposed to a more overarching power when traffic victims commit crimes which are integral to their status. Right, so next up, our last speaker, and most definitely not least, is Zoe Harper. She's a barrister here. She specialises in immigration, human rights, border protection and public law, and she has particular expertise in cases involving trafficking, gender-based violence, mental health and disability, and she is going to absolutely take up this very last point. That is what happens when our government, certainly this one, begins to legislate, and she's going to look through those aspects of the dreaded, I think I can say that, dreaded nationality and borders bill, those aspects that specifically impact victims of trafficking, in particular, the way in which it seeks to disqualify those who would ordinarily be victims of trafficking, running roughshod through the protections that we have grown to understand to be protection. So thank you, Zoe.
Good evening. I'm going to be speaking about the bill and the very serious threat to access to protection for victims of trafficking and others that it presents. Next slide. The provisions on trafficking are at clauses 46 to 57 of the bill, and it extensively rewrites areas of trafficking legislation and policy. There are problems in each of the clauses, but I'm going to speak to just a few provisions that fit with the theme tonight of considering how legislation and policy consider who is properly a victim. In doing so, next slide, the first thing to note is that this is an immigration bill, principally a borders bill, focused on increasing immigration control. And this is very much the focus of the legislation. So although the government gaslights us by reminding us of the importance of tackling modern slavery, in reality, much of the focus of this bill is around restricting borders and increasing immigration control, and not least in terms of the protections available to victims of trafficking. As one example, there is a power in the bill, clause 57, given to the Secretary of State to define victim of slavery and victim of trafficking in regulations underneath this bill. And one has to question why that might be. There is already a definition in the Modern Slavery Act of victim of trafficking and modern slavery that accords with the international definition, and yet there is this new power that enables, under an immigration bill, for the Secretary of State to redefine those concepts. Again, no detail is provided in relation to that. If there was any further need for the understanding of a kind of immigration-focused approach to trafficking and the conflation of immigration concerns with understandings of trafficking, then clauses 46 and 47 are a very clear example of the way that the bill disadvantages people from abroad who have been trafficked in the UK. Clause 46 requires that people who have an ongoing protection or human rights claim to provide any information about trafficking follow service of a slavery or trafficking information notice, very similar to the way a Section 120 notice works currently, where the Home Office provides a letter saying, please disclose any further reasons so that we can consider all matters together. There will be a specific notice asking a person to raise all issues of slavery or trafficking information within a specified period. The sting in the tail comes in clause 47, where a late compliance with that notice will be deemed to damage a person's credibility in the assessment of whether they're a victim of trafficking for the purpose of determining the conclusive grounds to identify if they're a victim of trafficking, their status, and their as a victim of trafficking and access to protection. it's clear that that the immigration non-compliance provisions are leaking into the assessment of trafficking status in the NRM process. It also cuts across guidance requiring the proactive identification of victims, and victims who receive this letter are supposed to come forward to identify themselves as victim of trafficking to the authorities, despite what we all know of victims of trafficking delaying disclosure, not recognising themselves as victims. But also the Home Office's own guidance recognises these issues of mental health concerns, preventing people coming forward, fear, ongoing control of traffickers, people not recognising their exploitation as such. And again, links back to what Siobhan was saying about male victims of trafficking who may not see themselves as victims because of cultural definitions and understandings of men in different cultures, including our own, not being willing to see themselves as vulnerable. And so all these barriers to unrecognised barriers by the Home Office to coming forward as a victim of trafficking risk if a person doesn't provide information soon enough, as damaging the credibility of their assessment as a victim of trafficking. And this can be seen as discriminatory. It treats victims of trafficking differently. So a person who is in the immigration system without leave to remain, who makes a delayed claim as or is identified as a late stage as a victim of trafficking, the assessment of their status as a victim of trafficking will inevitably be different to the assessment of the status of a victim of trafficking of somebody from the UK, because there is this additional barrier within the immigration process that already sets them up as potentially less credible because of their delayed disclosure or delayed identification. And so it entrenches that discrimination that we already see in the statistics of people from abroad being less likely to be recognised within the NRM system than people from the UK. And as that discrimination becomes more entrenched, it becomes more it becomes less likely that people are properly identified as victims. Further, clause 48 rewrites the reasonable grounds threshold. It's a fairly technical amendment to the wording with very limited rationale from the Home Office. But the amendment of the wording of reasonable grounds threshold from where someone believes a person may be a victim of trafficking, moving to language where someone believes a person is a victim of trafficking, does seem to confuse rather than clarify, as the Home Office suggest. The threshold of may be a victim of trafficking has again across a range of case law a range of case law has been understood as part of the necessary threshold when looking to identify victims, of suspecting a person is a victim of trafficking and not able to prove a victim of trafficking. That first initial threshold brings someone into the system in order to probe further. The case of DT illustrates just how important it is to have a low threshold for identification of victims of trafficking on the reasonable grounds threshold. The young man in TDT was identified as a victim of trafficking by his solicitor on the basis of indicators of trafficking. In that case, the he was from Vietnam, and we know there's a high incidence of trafficking into the UK from Vietnam. And there were other indicators such as his illegal entry and psychological indicators, which gave rise to a credible suspicion that the Home Office failed to properly investigate. There's a risk that if a more restrictive view is taken of that reasonable grounds threshold, that people in those circumstances are less likely to be identified. My own research into sexual exploitation has demonstrated that that restrictive understandings of victims of trafficking, or stereotypes around victims of trafficking, lead to the restrictive identification of victims, because people aren't looking widely enough in order to proactively identify victims. And then that becomes a self-fulfilling issue where fewer and fewer victims are identified, and the problem is more and more hidden. However, in clause 51 of the bill, next slide please, we move from exclusion through stereotyping and limited understanding to the explicit exclusion from protection and identification of more unpopular victims. Under clause 51, a victim is excluded from identification and protection where that they are considered to be a threat to public order, and that's defined, or they have made their claim in what's called bad faith. This arises at the stage of the reasonable grounds decision that this assessment is made. And so that means that a person who fits these categories would not be identified conclusively at all as a victim. Next slide, please. And further in the clause, we see the types of people who would be excluded from identification as a victim altogether. And so we have in clause A, for example, and C, the kinds of people mentioned by Mayor at the sharp end of understanding of the definition of people who are considered to have been involved in terrorism. At D, or even where there is a reasonable suspicion that they have been involved in terrorism related activity, not even having been convicted of such. In addition, there's an exclusion for a person who would be a foreign criminal identified within the meaning of section 32(1) of the UK Borders Act. So that's a person who has been sentenced to 1 year or more imprisonment in the UK, or is otherwise a persistent offender, so a number of low-level offences. So this would appear to exclude victims of trafficking who have a conviction of 1 year or more from being considered a victim altogether. So whereas we have a policy now where there are provisions in policy that would exclude a victim of trafficking from automatic deportation, here we have the opposite, that a conviction that might lead to automatic deportation automatically excludes somebody from being considered a victim. So sweeping changes there in terms of disqualification. Bad faith is not identified or defined at all, and that could be extremely vast in terms of what is meant, and it's unclear why that is even necessary. So, for example, if a person makes a claim and is not found to be a victim of trafficking, they're simply not identified. There's no real need for further provisions around making claims in bad faith, and there's a risk that this is used to catch people, for example, who don't tell the truth about having been trafficked because of fear of their trafficker or being in control and under control. and then not being, then if they're considered to have acted in bad faith from the perspective of the Home Office, then that potentially also excludes them from identification altogether. Not only does identification impact on the individual themselves, but it also fails to disrupt the cycle of trafficking that maintains people in trafficking circumstances and emboldens traffickers to continue trafficking others. Next slide, please. Although our focus tonight is discussing the trafficking provisions, I want to briefly mention the assault on refugee protection in the bill as having a devastating impact on the protection of victims of trafficking. Trafficking victims are often reliant on refugee and humanitarian protection to protect against return to situations where they face re-trafficking. We know that the leave granted to victims of trafficking under the trafficking policy of 1 year, that is not usually renewable, doesn't offer the kind of protections that people fleeing those kinds of circumstances need, and therefore the refugee provisions in the bill have a particular impact on victims of trafficking, and also their circumstances are likely to make them particularly vulnerable to the kinds of provisions in the bill. The refugee sector has analysed these in considerable detail, and it's worth thinking about those from the lens of a victim of trafficking, because many have similar and increased impacts upon them. For example, the focus in the immigration bill of considering claims inadmissible if a person has travelled through a safe third country or has connection to a safe third country has no exclusions for victims of trafficking at the moment, and entrenches the provisions that Michelle has described entrenches the provisions that Michelle has described in the immigration rules and places them in statute. The penalisation of victims continues in the reinterpretation of Article 31 of the Refugee Convention, and the separate provision in the bill where people whose claims are considered in the UK and have not come directly from the first safe country, or have delayed their claim, or have been in the UK unlawfully without good reason, there's a power to subject them to differential treatment in terms of the status that they might receive, a much shorter, more limited period, the requirements that they might need to meet for permanent stay in the UK, the risk that they may be subject to provisions that exclude them from financial assistance in the UK and limit the ability to bring family members to join them in the UK. Victims of trafficking risk being particularly vulnerable if they're considered to, for example, have delayed their claim through late disclosure or non-identification. There are a number of other provisions in the bill dealing with late evidence that somewhat mirror the late evidence provisions on trafficking status, as well as a new attempt at establishing a detained fast-track process, which we know had a disproportionately harmful impact on victims of trafficking who were the subject of one of the early challenges to the structural unfairness of the original detained fast-track process. Next slide.
So we're running very much.
Yes, I know. I'm wrapping up. So I was just
to wrap up, please.
Wrapping up to say that this isn't settled law. It's still a bill, which means that there's still opportunities to influence it. At the moment, the bill is at its committee stage in the Commons. That's a particularly important stage to influence, because the bill is going through a line-by-line assessment, and really important that individuals and organisations are in contact with their MPs and are supporting amendments with evidence. So I'll leave that there, but very bleak news from my side.
Thank you so much. I'm very sorry to our audience. We have run over, but I don't want to lose the opportunity for you to be able to ask questions, particularly when we've got such an eminent panel. And I imagine that there's people who want to ask Siobhan a few questions. I'm going to hand over to Catherine to field those questions. And thank you to our panelists for staying on to deal with these questions.
Thank you so much, everybody. And thank you, can I say, to all the panelists. It's been absolutely fascinating. There's been a few questions about the identification of victims and non-punishment in the Q&A, unsurprisingly, so I'll try and group them. Gillian from the Scottish Refugee Council asks, how early in the criminal justice process do you think the non-punishment principle should be applied? And do you think a referral to the NRM is sufficient for law enforcement or prosecutors to have fulfilled their obligations? Siobhan, Professor Mullally, because you're in the firing line, I don't know whether you want to take that or...
Well, very quickly, I think the quick answer is as early as possible, because it's closely linked to identification and to ensuring assistance and protection. So in terms of the report that I presented to the Human Rights Council, which draws on many submissions and engagement from Catherine and others also, the recommendation is that the obligation of non-punishment should be applied as soon as there is a reasonable grounds indication that a person is a victim of trafficking, but it may also be applied earlier wherever a trafficking claim is raised. So as early as possible, I think, is the best answer, and the specifics of NRMs and how they operate in each jurisdiction, others may be better positioned to answer that. But it's critically important that any prosecution or any proceedings are stopped while the identification process is ongoing, and non-punishment should kick in as at least where there is a reasonable grounds indication.
Thank you. And I suppose just to bring others in, there's a follow-up question about what more can be done to identify and protect victims of trafficking on the ground, including by the authorities at national government level. And I think the question, if I may also extend it to what more can be done to identify and protect victims of trafficking abroad, including where the state's responsibilities are to identify victims of trafficking at all parts of the trafficking chain, as in Rantsev. Maya, do you want to, Maya Foa, or either of the Mayas, do you want to come in on that question?
In terms of what more can be done to identify further victims, I think starting by acknowledging that individuals can be trafficked out of Britain, starting to have that conversation, starting to change. Obviously, I'm working on the case of the individuals detained in northeast Syria, so really looking at that context. And if you look at the public dialogue around it, there really isn't the recognition that people didn't always choose, quote unquote, to travel and join ISIS. So I think we're going to struggle in certain domains to recognize victims abroad whilst we have, or at least in the context, in these difficult contexts where we have unsympathetic potential victims. So I would start with the people that we know about and try and get them recognized and go from there. Obviously, we need to push back on the position that Britain has taken, that they don't have to recognise victims when they've been trafficked out.
Thank you. And does anybody else want to come in on that in terms of the international state obligations? Anne, is that a hot topic for you in terms of state responsibility to identify victims here or abroad? What more can be done on the ground?
Well, yeah, I think Siobhan might have something to say on that, but Catherine, I think the key is something that has been repeatedly emphasised throughout this session, and that is identification is critical. If you're not having the identification, and if states are not being compelled to give a interpretation of the definition of trafficking that was perhaps beyond what they originally envisaged, then we're going to have this constant tussle between the narrowing and the attempts to expand. And until identification, identification is that's the key element in all of this.
Yeah, and just to add to that, I mean, I think we can just look at the ordinary law on human trafficking and ensure that it's applied. So looking at the jurisprudence of the European Court of Human Rights, RANSAF, the obligation to look at all stages, including through international cooperation, and then looking at the procedural limb and the obligations of that arising from that under Article 4, wherever credible suspicion arises that trafficking may have occurred, that the positive obligations are triggered of identification, assistance and protection. And those apply also, as Maya said, when somebody is being trafficked out of Britain. And in terms of what constitutes assistance and protection, then certainly what we're getting from the Committee on the Rights of the Child would suggest that that can include provision of consular assistance. And I would suggest it can also include the obligation of repatriation, shall facilitate and accept. But also looking, as I think has been highlighted by many, the other obligations in terms of risks to life, the absolute prohibition of torture, inhuman and degrading treatment, and how all of that is linked in to the trafficking chain and the positive obligations there. But on the ground, what it means is that recognizing the credible indicators that are before us and all of the tools that we see in other scenarios, the use of dating apps, for example, that Maya was talking about. We know, and it's accepted in trafficking conversations, that that's a tool that's widely used. So why is that not also being recognized in this context? So it's this problem of the unpopular victim. And it does, I think, engage the state's obligations of non-discrimination.
Thank you. And on that issue of non-discrimination, this was at the heart, of course, of each and every one of these fantastic presentations this evening. Can I ask each and every one of you, if possible, how do we use the non-discrimination principle in a transformative way, either in a gender transformative way or in the way, you mentioned the rights of the child, in the way the best interest principle can be used in a transformative way, or should be? What's the most effective way to argue this? Do you think normatively, practically? Siobhan, because you're here again. Can I?
Okay. I can see Michelle.
Michelle.
Yeah, Michelle. Siobhan, why don't you go first and then I can jump in afterwards?
I must say I did want you to speak, Michelle, because you mentioned discrimination as part of your challenge on the safe third country. Please.
Okay. Well, I think with discrimination, all I was really going to say is, I think really identifying what the impact is on the victim of trafficking and thinking about how you define that, how you explain that, how you evidence that, and why these policies, I mean, some of them are overt, like the policy I discussed, the inadmissibility policy. It's actually direct discrimination against a victim of trafficking. But you have other policies that their impact on victims of trafficking is going to be different and worse than on others to whom that policy might apply. And I think we're going to see that a lot with the new policies coming through in the bill that maybe aren't directed at victims of trafficking, but will affect them particularly badly. So I really wanted just to comment on it in that way, that it's a lot about trying to understand those impacts and evidencing them in order to build strong arguments in support of discrimination claims.
Thank you, Michelle. And can I ask Zoe as well, in terms of the bill, for example, late disclosure only applies to victims of trafficking with a protection and human rights claim, or how can we use discrimination to defeat the bill, all of it?
I wish I had that magic bullet. I mean, I think that the bill is going to be imperfect. I mean, I think things that we can be thinking about for this immediate stage and subsequently are positive amendments that proactively put protections in there. So, for example, you could positively have amendments crafted to create the kinds of protections we want to see, the kinds of anti-discrimination we want to see. And that's certainly something we can be thinking about pressing as the bill goes forward.
Thank you so much, Zoe. I think as the clock has struck midnight, you might have to all disappear.
Yes.
But thank you so much. I'll hand over to Maya.
Oh no, sorry, Catherine. I just want to say I'm sorry. We have really run over, and I'd love to just stay here, especially with such brilliant panel and chat for longer. But we can't. So it remains really for me to thank our speakers again for sharing their learning with us tonight and for keeping this really important conversation going, and also for all that each of you do every day to challenge discriminatory thinking. So thank you, and thank you so much to our audience for joining us here today on Anti-Slavery Day. Thank you all so very much. Have a good evening all.
Thank you so much.
Bye.
Thank you.
Thanks.